and I'm on the National RMLA Committee and hosting the webinar today. We have had over 180 registered attendees, which highlights the interests in the issues to be discussed today. The purpose of the webinar is to bring together speakers with a mix of expertise, practicing locations, to provide a range of views on the topic of implementing the NPS for highly productive land. We are very grateful to have 3 experienced practitioners speaking today, who I will introduce shortly. In terms of housekeeping, please use the Q&A function at the bottom of your screen throughout the presentation to ask any questions. We will wait till the end of the presentations to answer as many of those as possible. If everyone can also please ensure that your cameras and microphones remain off throughout the presentation. Our first speaker today is Rebecca Eaton. Rebecca is a Senior Associate at Govett Quilliam based in New Plymouth. She primarily practices in resource management, has previously presented on the NPS for highly productive land, and has been providing advice in relation to its implementation. Rebecca is the current chair of the Taranaki branch of the RMLA, and she will start by providing an overview of the NPS, its background, key provisions, and looking at some of the cases coming out of the courts so far. Our second speaker is Dr. Reece. He is a soil and land resources consultant from LandSystems based in the Waikato. Reece will focus on the mapping required under the NPS and the work that's underway around the country already. As you will hear from Reece, he has undertaken more than 200 high-class soil and highly productive land assessments across the country in his career to date. Our third speaker today is Jonathan Clease, who is an experienced planner and a partner at Planz consultants based in Christchurch. Jonathan is also an accredited hearings commissioner. Jonathan has been involved in plan changes and resource consent applications where the NPS has been a factor, including the recent plan change appeal involving the Selwyn District Council, where the Environment Court issued a decision last Friday. Today, Jonathan will focus on some of the key clauses in the NPS and provide comments from his planning perspective. I would like to extend a warm welcome to each of our speakers, and I will now hand over to Rebecca Eaton to get the presentation underway.
Kia ora koutou. Hi everyone. As Kate mentioned, my name is Rebecca Eaton. I am a Senior Associate at Govett Quilliam in our resource management team. And like many of you, we have been advising on and at times grappling with the NPS HPL over the last year. As Kate mentioned, today I will be providing a brief introduction and overview of the NPS, focusing on its implementation, as well as providing a brief case law update. We have a heap to get through today with our speakers, so I will jump straight in. So firstly, looking at the background and intent of the NPS, I think it is always important to cover off the key issues that national policy are seeking to address. The stated policy intent of the NPS HPL is to focus on the key land use planning issues affecting highly productive land, which include urban rezoning and rural lifestyle development, intruding on HPL, reverse sensitivity effects, reducing the productive capacity of that land, and the fragmentation of HPL resulting in that land no longer being suitable for primary production. That intent has really flowed through to the overarching and the sole objective of the NPS, which is contained in clause 2.1, and that is that highly productive land is protected for use in land-based primary production, both now and for future generations. It's probably helpful to note here that land-based primary production is defined as production from agricultural, pastoral, horticultural or forestry activities that is reliant on the soil resources of the land. And this definition is deliberately narrower than the definition of primary production, which is found in the National Planning Standards. The NPS also contains highly directive policies, and I've just put up 5 of the more directive policies here, and just highlighting in particular the avoid policies in policies 5, 6 and 7, seeking the avoidance of urban rezoning, rural lifestyle rezoning and development, and the avoidance of subdivision. So this is extremely directive language that's being used in these policies with the use of avoid, prioritise and protect. As many of you will know, the Supreme Court in King Salmon confirmed that avoid ultimately means to not allow or to prevent the occurrence of. Moving on to the implementation of the MPS, it came into force on 17 October 2022. The MPS was approved by the Governor-General on 12 September, so that is a pretty fast turnaround time to commencement. And understandably, a number of local authorities and applicants were caught a bit off guard by the speed in which it came into force. And that's particularly given that aspects of the MPS have immediate legal effect. And we will discuss that in a few minutes. In terms of mapping, clause 3.51 sets out the regional mapping requirements, and regional councils must, as soon as practicable and no later than 3 years after the commencement date, notify in a proposed RPS by way of maps all land in its region that is required by clause 3.4 to be mapped as HPL. So in terms of timeframes, we're looking at the latest date being the October 2025. And this must be done via a Schedule 1 process. Clause 3.4 provides guidance and criteria for regional councils in assessing whether land is HPL. And as flagged, Dr. Reece will be speaking more about the process and assessment of regional mapping later in this presentation. In terms of district plan mapping, that's covered by clause 3.52. And as soon as practicable and no later than 6 months after an RPS containing maps becomes operative, every relevant territorial authority must identify the HPL in its district and must do so using maps that are exactly equivalent to those in the RPS. And this process is subject to section 55 subclause 2 of the RMA, meaning that amendments can be made by district councils without using a Schedule 1 process. So the focus is really on the regional council mapping here. In terms of the amendment of the content of district plans, clause 4.1 subclause 2 provides that every territorial authority must notify objectives, policies and rules in its district plan to give effect to the MPS as soon as practicable, but no later than 2 years after maps of highly productive land in the RPS become operative. And this must also be done by way of a Schedule 1 process. So this is the final step in the amendment of plans, so taking us out to potentially at least 5 years post the commencement date, which is October 2027. Finally, turning to the immediate legal effect aspect that I mentioned, under clause 4.11, every local authority must give effect to this MPS on and from the commencement date, noting that until an operative RPS containing the maps of highly productive land is operative, highly productive land in the region must be taken to have the meaning in clause 3.57. And we'll talk about this transitional definition shortly, as it's already been quite a contentious and important area of the MPS. The immediate legal effect of the MPS has differentiated this MPS from other national direction. And I think it is what it's fair to say has caused some disruption and confusion, particularly for planning and consenting processes that were already underway at the date of commencement. Turning quickly to some of the relevant implementation clauses for applications. In the interest of time, we're unable to go through all relevant substantive clauses in the MPS, although both Reece and Jonathan will touch on some in their aspects of the presentation. But I've just flagged here a table of the key clauses that are likely to be relevant for various applications. For plan change applications, that will be 3.6, 3.7 and 3.10. The land use consent applications, that is likely going to be predominantly 3.9 and 3.10. And for subdivision consents, 3.8 and 3.10. Turning now to what is referred to as the transitional definition of highly productive land. In order to prevent a gold rush of applications prior to the completion of the regional mapping, the MPS HPL includes a transitional definition of HPL, which is to be used from the commencement date until HPL is mapped in an operative RPS. And this transitional definition is contained in clause 3.57, and this clause is expressly included in the overall definition of highly productive land. So it's a bit of a mouthful, but I'll take you right through clause 3.57 because it is important. It has multiple parts. So I think it's important to take you through the entire clause. So until a regional policy statement containing maps of highly productive land in the region is operative, each relevant territorial authority and consent authority must apply this national policy statement as if references to highly productive land were references to land that at the commencement date is zoned rural, general rural or rural production and is LUC 1, 2 or 3 land, but is not identified for future urban development or subject to a council initiated or an adopted notified plan change to rezone it from general rural or rural production to urban or rural lifestyle. So there are both qualifying aspects of this transitional definition under subclause A, as well as 2 exemptions under subclause B that can exempt applicable land from the MPS HPL during this transitional period. For the purposes of today, I'd just like to focus on those exemptions. The first exemption under subclause B, which is identified for future urban development, is also defined in the MPS itself, and apologies, this is a bit of definition jumping. So identified for future urban development is defined as identified in a published future development strategy as land suitable for commencing urban development over the next 10 years, or identified in a strategic planning document at a level of detail that makes the boundaries of the area identifiable in practice. One more definition, strategic planning document is also defined as any non-statutory growth plan or strategy adopted by local authority resolution. So we understand there are a number of councils who have not yet published their future development strategy under the MPSUD, nor do they have growth plans or strategies that have been formally adopted by resolution. So that rules out the first exemption for a number of districts. The second exemption under subclause B relates to land that is subject to a council initiated or adopted notified plan change to rezone the land from rural to urban or rural lifestyle zones. The interpretation of this exemption, the second exemption, has already seen contention across the country, particularly in the context of ongoing plan reviews. Earlier this year, the decision of Judge Stephen was released, making a ruling on the correct interpretation of this exemption. So that leads me nicely into the case law update section of my presentation on some of the key cases that have been released and which have assessed the implementation of the MPS HPL. First up, we have the decision of Judge Stephen and the Balmoral and Dunedin City Council, which, as I flagged, looks at the transitional definition of HPL and in particular the second exemption. And if we could just change slides there, Michelle. This decision addresses a group of appeals on the Dunedin second generation city plan, which was seeking site-specific rezoning. The land subject to the appeals was all rural zoned under the notified plan, with the appeals and their respective submissions seeking urban and residential zoning of the sites. The relevant appeals had already been scheduled and evidence had been exchanged when the NPS HPL came into force. So at that point, the evidence had not addressed the subject matter of the NPS. The preliminary issue that arose was whether the court, in considering these appeals, should have regard to the provisions of the NPS HPL, and specifically whether the sites under appeal met that second exemption of the transitional definition. So whether the land was subject to a council initiated or an adopted notified plan change to rezone that land. The council argued that the land under appeal met the first criteria of the transitional definition and did not fall under the exemption criteria under clause 3.57b. So the council's position was that the NPS HPL did apply. The appellants argued that because their submissions and their appeals sought a form of urban rezoning, that this meant that the appellant's land was the subject of a council-initiated plan change, and that brought it within the scope of that second exemption. However, the court found that this submission was difficult, if not impossible, to reconcile with the language used in clause 3.57. The court found that to come within this exemption, the rezoning has to be reflected in the plan change initiated by the council at the notification stage. Submissions or appeals lodged in the course of the Schedule 1 process seeking an urban rezoning would not meet this exemption. Further, the court found that the NPS distinguishes between plan changes initiated or adopted by the council and submissions and appeals that have been lodged on the plan seeking urban rezoning as an outcome. So a submission or an appeal seeking a rezoning does not have the effect of making the land subject to a council initiated plan change. So in this case, the court found that the NPS HPL did apply to the appeals. And if we could just have a slide change. The court found that there were no retrospectivity or natural justice issues in taking this approach. In looking at the natural justice issue, the court highlighted that each NPS has its own implementation and transitional arrangements. So the case law that had been relied on quite heavily by the appellants regarding the implementation of other national direction, particularly the NPS FM, was of little assistance in resolving the issue before the court. And the court found that the NPS HPL applies prospectively to matters which the council or the Environment Court are required to make decisions about from the commencement date of the NPS HPL. The court also clarified that the additional regional mapping criteria that is required to be considered by regional councils is not included in the transitional definition. For the purposes of the transitional definition, it is sufficient that the land is rural zoned and it is LUC 1, 2 or 3 land, and that neither exemption applies. In particular, the regional council mapping requirement that land must form part of a large and geographically cohesive area does not apply to the transitional definition. So there is some distinction there between the ultimate determination of HPL once regional mapping is completed and the determination of HPL under the transitional definition. We understand that there were a heap of plan reviews afoot at the time that the NPS HPL came into effect. So this case does provide some helpful direction regarding the exemptions, particularly the second exemption, and provides authority that submissions and appeals seeking urban or rural lifestyle rezoning will not on their own be captured by the second exemption. Moving on to the second case for today, we've got Grey and Dunedin City Council. This was also a Judge Stephen case. The appellants appealed a decision to decline resource consent for a residential activity on a 2.8 hectare lot in the rural zone. The court looked specifically at how the NPS HPL applies to resource consenting in the interim period prior to the inclusion of mapping and provisions in plans. The court took the view that clause 3.9, which was relevant here and relates to the inappropriate use and development of HPL, is largely dependent on decisions that was yet to be made by the councils as they amend their plans in accordance with the NPS HPL. Ultimately, the court found that the provisions of the NPS, including 3.9, were among the range of matters that a consent authority must have regard to when assessing a resource consent application. The court found that the proposed activity was not an appropriate use in terms of the NPS definition. The Indigenous vegetation restoration proposal element of the application would likely be consistent with the exclusions in subclause 9E or G, and may have even come within the further exemption in clause 3.10B due to the small size of the site area. But interestingly, the court didn't really provide any further analysis on these clauses. and just left those statements there. But perhaps the most interesting takeaway from this case is that the court was not prepared to give any weight to the MFE guidance on the NPS HPL, and that guidance included an example list of inappropriate activities for the purposes of assessing clause 3.9. The court reiterated the Environment Court's previous position, which had been made in respect of the NZCPS, that government guidance notes, while helpful, have no statutory basis and are not legally binding. So this is really significant, as the guidance documentation includes a lot of additional information intended to assist users with the implementation of the NPS and to clarify areas of uncertainty. For those of you who've seen it, the latest MFE guide to implementation is 75 pages long, and that compares to the NPS itself, which is 15 pages. So it's understandable that it's been used by local authorities, applicants, and technical professionals in assisting their understanding of the NPS. But the decision in grey suggests that if there is a need for MFE guidance to be so comprehensive but cannot be relied on, perhaps more direction should be being included in the instruments themselves rather than in guidance documents. In the meantime, users of the NPS HPL should be cautious when using the guidance documentation and avoid placing significant weight on the implementation guide itself in decision making. However, and just to add a further spanner in the works, last Friday the Environment Court released the decision of Drinnan and Selwyn District Council. And in this decision, the court did place some reliance on the 2022 MFE Guide to Implementation. That was in reinforcing one of the views it took on the provisions of the NPS. So this is somewhat a live issue, but we would continue to suggest caution in relying on the guidance documentation itself. In terms of the substantive appeal, that was ultimately allowed. Finally, we have the recently released decision of Judge Semple, which is Barbican Securities Limited in Auckland Council. This was an appeal against an Auckland Council decision to decline an application for a 3-lot subdivision on rural zoned land. At the time of the application, the land was used for dairy grazing. The court confirmed that an operative NPS, the NPS HPL could have regard to the relevant clauses of the NPS HPL as they stand, despite the fact that the Auckland Unitary Plan had not yet been varied to give effect to the NPS. So the court in this case has gone further than the court in Grey and Dunedin City Council regarding the current status of the clauses in the NPS HPL in relation to consent applications. In this case, Policy 7 and Clause 3.8 were applicable, which requires the avoidance of subdivision of highly productive land. In particular, the Clause 3.81a exemption was relevant, and this clause provides that subdivision must be avoided unless the applicant demonstrates that the proposed lots will retain the overall productive capacity over the long term. The court made a finding of fact that the subdivision as proposed would retain the status quo, so the land would continue to be used for its current pastoral use, regardless of whether the subdivision consent was granted or not. On this basis, the court found that the overall productive capacity of the site would remain the same and therefore would be retained. It was interesting to see that in its assessment, which was quite detailed, the court did not directly reference or analyse the express definition of productive capacity, which is included in the NPS. And it was fundamental in this case that in addition to the existing dwelling, a further principal dwelling and an accessory building could be built as a permitted activity provided development standards were met. And there was also the right, either by way of existing consent or existing use right, to replace a dwelling which had been destroyed by fire in 2022. So when considered against this possible scenario, the court accepted the planning evidence that approximately 0.3 hectares of additional land might be removed from future rural productive use if consent was granted. and that amounted to 0.5% of the total area of the site. This conclusion of fact was despite the fact that the applicant had stated its aspiration for future urbanisation of the land. The court stressed that its assessment in this case had to be based on the application before it, not any future application which has not been applied for and may or may not be granted in the future. The court also looked at Policy 8 regarding inappropriate use and development and held that, given they'd found that the land would be retained in land-based primary production, that the subdivision as proposed could not be deemed to be inappropriate use or development. Despite the finding that the proposal was not contrary to the NPS HPL, the appeal was ultimately declined and consent refused. We do anticipate that clause 3.8, and particularly the interpretation of retaining the overall productive capacity over the long term, will be an ongoing and contentious aspect of the NPS HPL. The Barbican case highlights that it will be a very fact and case specific exercise in pulling that exemption apart. This decision included quite a detailed analysis and assessment of the evidence before it, particularly the very conflicting economic evidence. So that's it for the cases we've been able to cover today. There's been a number of recently released decisions and a number of upcoming decisions that we expect to see in the next month or so. So we can expect to see some more court guidance in the coming months, and hopefully that will clear up some of the remaining areas of uncertainty. That's it from me today. There's a lot to unpack with this NPS. We could be here all day talking about it, but no one wants to be doing that. But hopefully you found this update and overview useful. And I will pass you on now to Dr. Reece Hill.
Thank you, Rebecca. As Kate mentioned, my name's Dr. Reece Hill. I'm a soil scientist working as a consultant. I have been for the last 4 years, looking at basically soil mapping and land LUC mapping. Prior to that, I was at the Regional Council as a soil scientist and manager there for 20 years, past president of the New Zealand Soil Society, while at the time when we put in a submission at the early stage of the NPS HPL. I'm just going to, Michelle, I can't quite see my full screen, so I'm going to go off my the other screen, and I'll just tell you when to move on to the next slide. So what I'm going to cover today is really my interpretation, my opinion on the mapping that I've undertaken to date and how that's in practice some of the issues that have been raised. Rebecca's given a pretty detailed description of the definition and the guidance, so I won't go into that, but I will cover some of the data available for the transitional definition and then move on to regional mapping. The approach, a bit of an approach overview, as well as the data available for doing the regional mapping and some of the progress to date and the use of site-specific assessments. Okay, if we move on to the next slide, please. This one really is all about the definition, so I won't go into this. Needless to say, Rebecca did mention that the main difference between the transitional definition and the final regional council mapping is one of the differences is that there's no requirement to consider whether it forms a large and geographically cohesive area. And as mentioned, the implementation guidance came out in March 23. Next slide, please. In terms of the available data for the transitional definition, the main source is actually provided by Manaaki Whenua Landcare Research, and this would be where most people would go and seek whether their land is class 1, 2, or 3. You can see the screen print of the site of the website there. You can zoom in, but essentially the information provided is derived from the NZLRI LUC map information or layer from the original 1 to 50,000 scale maps. The thing to note there that it is based on dominant LUC only, and so it doesn't include, it doesn't put any context around the inclusion of LUC classes within those map units that may not be highly productive land. And that's fair given that they are subdominant anyway. Next slide, please. So in terms of limitation for the available data, well, these have been recognised in the NPS, and it's really around the scale of the maps and the age of the data. That the LUC maps were compiled or compiled and on the mapping done and the information provided originally in the 1970s and 80s, and they've subsequently been put into electronic format more recently at a scale of 1 to 50,000. The soils don't necessarily follow easily identifiable geographic boundaries such as river boundaries, roads and land parcels, etc. And as within the mapping units, the LUC 1, 2 and 3, you can have what's called compound units here that do include other LUC classes that are subdominant. So when we look at the soil information and the soil surveys that sit under this, the little image there that I've got, if you focus on the dark areas, these sources of soil survey information are actually at a scale that's not 1 to 50. They're at a scale that ranges there from 1 to 26,000, I think, to 1 to 250. Sorry, 1 to 26,000 to 1 to 250,000 scale. And some of that information is actually based or from surveys that were done across the whole country at a very broad scale in the 1950s and 60s. So if we were to then look at using those boundaries for an individual lot or parcel of land, especially if it's small, it may be that half of that parcel is considered or mapped according to the 1 to 50,000 scale as being not highly productive land, i.e. not LUC 1, 2 and 3. But in reality, applying those soil boundaries from the broad scale maps likely to be quite misleading. Next slide, please. LUC class 1, 2 and 3 land is defined in clause 1.3 as land identified as land use capability class 1, 2 or 3 as mapped by the NZLRI or by any more detailed mapping that uses land use capability. The more detailed mapping includes things, map information such as SMAP, which is the electronic soil map for New Zealand. But it doesn't include or is not intended to include the site-specific assessments prepared by landowners. And this has been kind of mentioned to me as being a little bit contrary to other national policy and consent approaches where, for example, with contaminants in soil and wetlands and freshwater, we have ecologists and we have on-site assessments to find out what the actual levels of contaminants are and where the wetlands are. And also, when we look at geotechnical, we don't use a broader map. We actually go onto site and figure it out site-specific, which would be considered a more appropriate scale. And what I've found is that some councils are currently, in terms of LUC maps, are actually still requesting and accepting site-specific assessments, whereas others aren't. So there's quite a bit of variability in terms of the approach across New Zealand. Next slide, please. The site-specifics, I've got some examples here. This one here, if you focus on the green, large green area, and then below it, the area that's outlined with the black boundary there, that all is part of one LUC map unit in the NZLRI with a dominant LUC class of 3. So it's actually mapped as units 3S6 and 6E19. And when we used more detailed slope maps, and we identified that that portion in the black boundary was dominantly the 6E19 area because the slope was greater than 15 degrees. And so for that development, they were able to say that even though the greater LUC map unit was predominantly 3S6, it didn't apply to that area. There are some areas on there that are little green areas, which are highlighted with the blue boundaries. And they were seen once we examined their photos, etc., found to be the result of earthworks to do with placing houses and residential areas in there. Second example relates to some of the on-site mapping I've done in places. I've highlighted at the top there, you see in each of the slides A, B, and C, the photos, erosion. So these are the limitations that help define what LUC class it is. So the first one's erosion, then there's wetness and soil depth. These are examples. All of them were mapped under the NZLRI as class 3. However, once we did the on-site inspection or assessments, they clearly weren't LUC3, and for the photo in A, much steeper slopes and some wetter areas down the bottom. The B photo was much wetter and classified as 4W, and soil depth was much shallower in the example in C, and that was classed as 4 as well. Next slide, please. In this example, it really just shows on the left-hand side there, we've got what the NZLRI would classify as in green as the highly productive land based on the LUC classification. And then on the right-hand side is once we've done the on-site assessment, those areas changed quite a lot, and there's only a small amount of highly productive land. That would, applying the NZLRI mapping would probably be classed as a large contiguous area as well. Which would be kind of questionable if we were to use the on-site mapping. Next, please. In terms of the regional mapping, the sources of information, well, it's still, it's likely to still require or rely on the NZLRI LUC maps that we're using in the transitional definition, but there is opportunity for councils to use more detailed mapping where it's available. And some of these include the alternate mapping system that is still based on the LUC and the LRI, more detailed and up-to-date data that is accepted by regional council, NZLRI and LUC mapping completed by council staff, or mapping by professionals that's approved by council, and pre-existing soil conservation plans if completed by approved by catchment board staff. So these are some of the regions do have quite comprehensive updated LUC soil conservation plans available. But again, it excludes the individual site-specific assessments undertaken by landowners. The other sources that they can, for regional councils, that they can undertake more detailed mapping to inform the mapping. And this is really aimed at where the LUC isn't logical or reflective of recent soil surveys. For example, if we've got updated SMAP information that shows the soils are quite different, and it does have to use the latest version of the LUC land use capability survey handbook, and the soil survey has to be in accordance with the New Zealand soil mapping protocols and guidelines, and it has to be undertaken by a professional, either in LUC or soil mapping. Next slide, please. The regional mapping in terms of the overall approach, well, as I mentioned, it's going to be a desktop exercise, and with limited ability to refine the field mapping or do any field mapping, or and it will highly rely on the existing LUC maps, especially where these other information doesn't exist. So on the left-hand side there, we've got a map of where SMAP is being completed across New Zealand, and all the areas coloured there have been completed, and I think it adds up to around 60, 2/3 of New Zealand. That has taken some time. That's at least 15 years to get to that stage, so it's not a fast process. On the other side there, we have the LiDAR coverage, which is underway across New Zealand, so it's getting full or near full LiDAR coverage. But again, there are regions that won't have that information. Now, the LiDAR is useful for improving the boundaries where they relate to slope, and the SMAP should be useful to a limited extent about where we have LEC criteria relating to wetness and soil depth. Next slide, please. In terms of progress, well, from talking to some of those people involved recently, the progress is by regions is quite mixed in terms of how far along the process they are. It's predominantly been led by policy staff with some input from science and consultation with tangata whenua. The progress has, in my opinion, been is dependent on the importance of the issue in the region. So, for example, those like Auckland, Waikato, Canterbury probably are pushing forward a bit quicker. It is dependent on the level of knowledge of the issue in the regions, and finally the in-house capacity as it relates to those that can do the GIS, the spatial analysis to create the maps, and the science behind that, and the policy resources and capability. There has been a regional network established. This was initiated by Waikato Regional Council, and this includes most but not all regional authorities. However, the information will be disseminated to the other regional authorities, and they're preparing a position statement including the use of site-specific soil assessment. There's also been work undertaken, initial method criteria being developed by Manaaki Whenua Landcare Research. Next slide, please. A region or district may have a particular land-based primary production industry that relies on a class of land that's not LEC3. So in terms of further considerations, you know, these areas, well, for example, some areas that aren't, well, it might be considered highly productive land would outside the LEC 1, 2, and 3 could be those areas that are in viticulture, for example, the Gimlet Gravels, and some of them may be the Pinonwai areas of Central Otago. And the regional councils can include these. So what would be the outcome of that is that the area of highly productive land within those regions would be greater than would currently be under the LEC 1, 2, and 3. But I just note that the inclusion of this land is not, these areas would not be based on the versatility of the soil and land, i.e. having a wide range of land use options, if you like. It's more so to do with the specific production that comes out of those single enterprises. And another point is that I've noted there is we've had situations where the current condition of the land is quite different to how it was mapped in the 1970s NZLRI. It's been some time, and we have encountered areas that are now built areas, quarries, etc., that are currently mapped as NZLRI LEC Class 1, or well, more so 3 than 1 to 3, but are considered highly productive land if you apply those map boundaries. Next slide. Finally, the role of site-specific assessments. So as mentioned, it does not require widespread ground truthing in terms of the regional mapping or site-specific assessments of all potentially highly productive land across the whole region. However, individual landowners may attempt to use site-specific assessments by way of submission through the Schedule 1 process. I defer to Rebecca to clarify if that's actually correct. But I have had a number of landowners asking or requesting site-specific assessments to try and do that. My understanding from talking to regional councils that they do have discretion whether they accept these or any other detailed mapping. In any case, any mapping has to be undertaken by professionals and adhere to the guidelines in terms of the soil survey and the handbook guidelines. The detailed site-specific assessments may be provided and considered as part of a resource consent application rezoning as part of an assessment of the productive capacity of the land. So when we look at comparing the productive capacity of the land, these on-site assessments could be quite useful in making sure that we actually have the soils and we know the soils of and their properties and the LUC classes that are actually on there to put together a more kind of accurate assessment of the productive capacity. And as mentioned, the regional network group is working on this at present time. And that's all I have. So I will pass over to Jono.
Sorry, there I am. Hello, everyone. Thank you, Reece. Good afternoon. Hey, look, as a planner in a room full of lawyers, I'm always cautious about sort of interpretation. So I thought this afternoon I'd more sort of tell you about some sort of stories from the front lines, I guess, in terms of what I'm seeing at a planning level in terms of trying to implement and apply the HPL, and probably some of the key areas where questions and areas of greyness are coming into those assessments. So as Rebecca said, it's a very directive MPS with lots of sort of avoid and protect language, and as we all know from King Salmon, where you've got a very directive national policy statement, you don't easily sort of work your way around that with an overall broad judgment. And I think for me, it's this pendulum swing where our approach to versatile soils has gone from being an other matter, perhaps at best, right the way through to now actually very much a deal breaker for projects. And that pendulum swing, which has happened quite quickly, is what is at the heart of, I think, where people are wrestling with this MPS in particular. So very directive, first key thought. There we go. Next slide, please. So then the first question I find whenever you sort of mention this, people sort of want to dive straight in, employ someone like Reece to go out and do a soil test. But actually, there's a few key questions I think you need to sort of ask yourselves first. And the first question is the site actually HPL? As Rebecca said, we're currently in this transitional phase. My sense is that it will take the full length of those 3 years, like most statutory timeframes. They'll go to the wire before it's done. So we've got this 2-year period still to go. And until it's done, we rely on the LUC 1 to 3 maps. There is, and Reece alluded to this, I am seeing in practice some councils being open to the idea where LUC 1 to 3 has a definition. That definition includes unless identified through a specific soil assessment. So some councils are open to people getting their own soil assessment done, and if that can demonstrate that the land is not LUC 3, then by definition you're not caught in that transitional situation. As Reece said, it is quite variable practice-wise around the country in terms of whether councils are open to that approach or not. And then if you're not, in terms of that viability, or whether you are like 1 to 3, clause 3.10 isn't where you go. It's got to be the sort of mapping that shows that it's definitely not 1 to 3, whereas 3.10 is you are 1 to 3, but it's just got some constraints to it. Thanks, Michelle. So the key test for regional councils during this transitional phase, as we've heard, is a detailed mapping. Is the site fragmented? And this in particular is about fragmentation by soil type, not by ownership. And I've seen a lot of people put forward propositions to councils that, look, this area has got a whole lot of, chopped up into lots of 4 hectare blocks. It's already gone. Functionally really hard to sort of turn it back to a big dairy farm. But that's not the test. It's if it's all lot 1 to 3 that's connected, then that's not fragmentation. Then is it already urban zoned or identified in a strategic growth plan? This again is where I'm seeing quite a lot of greyness in terms of what counts as a strategic growth plan and whether the blobs and arrows are down to a cadastral level, especially if it's a big blob and your cadastral is clearly wholly contained within that blob. It doesn't matter if the blob's got fuzzy edges around it if you're clearly in the center. So I'm seeing quite a divergence of practice around whether you can kind of get in through that that gateway. And then lastly, is it a rural lifestyle zone? And this again is nowhere near as straightforward as it first appears. Thanks, Michelle. And this is especially the case where you have older district plans that predate the national planning standards, where you have to do your sort of a nearest equivalent test to, is it a rural lifestyle zone? That the MP's definition is up there in front of you all, and I'm sure the lawyers in the room will be able to spot opportunities for asking questions around whether any given rural zone ticks that box or not. And so just to illustrate this, Michelle, if we go to the next slide, please. A tale of two districts. So this is Greater Christchurch. Sort of Christchurch is in the middle there, Banks Peninsula down to the bottom right. Got Selwyn District to the southwest and Waimakariri District to the north. Both districts have proposed plans. Decisions on Selwyn just came out a couple of days ago. Both proposed plans were notified before the MP's HPL came into existence, so they're both quite sort of innocently, I guess, drafted in that regard. Selwyn in a Planz area, which is sort of next sort of commuter belt Christchurch really, big chunk of like 1 to 3 in there. They decided to have the entire rural area as a single general rural zone, but with a specific area tool that reduced the minimum subdivision size from 20 hectares generally down to 4 hectares in this area. So sort of Christchurch commuter belt, rural zone, 4 hectare minimum in this specific place. Waimakariri District adopted a very similar approach, 20 hectares across the rural zone in general, but in their bit of the sort of Christchurch commuter belt, again, 4 hectare minimum, but they decided to call their 4 hectare minimum area a rural lifestyle zone. So in terms of outcome, very little difference. But in terms of implementation of the MP's HPL, Selwyn's one, it is in play, but in Waimakariri, general agreement around planning professionals and legal in Christchurch is that it is not. So in Waimakariri District, we've got some sort of 200 square kilometres of HPL excluded from the MPS, and MPS not in play, simply through an innocent quirk of zone labelling made before the MPS HPL came into play. So this is going to be, I think, quite a real challenge for regional councils. Canterbury Regional Council in doing their mapping, I would suggest rather than diving straight into soil tests and mapping exercises, they need to first be looking across their 9 districts, most of which have got old pre-NPS district plans, and first doing a zone equivalency test. And especially for districts around the country that are low growth districts, often quite enabling in their rural zone rule packages. So if you have a zone that lets you subdivide down to sort of 4 hectares or 1 hectare or has no minimum, is that a rural lifestyle zone? When you look at the definition in the MPS. So big chunk of grey area there in terms of whether MPS is in play for your site or not. So next slide. Yep, so if you go through that exercise though, transitionally, MPS is in play. If you want to rezone to urban, you go to clause 3.6, not 3.10. If you want to rezone to rural residential, then you go to 3.7, which does provide a pathway through to 3.10. Interestingly for me, I think 3.10 is actually potentially an easier pathway to get through than 3.6. Yet the commentary surrounding the MPS made it clear that rural lifestyle zoning was actually seen as being the bigger thing to avoid. So it's just sort of a little quirk of which pathways you go down to get your rezoning through. Michelle? So if you are wanting to do urban rezoning under 3.6, then you have to pass the 3 conjunctive tests of clause 1, which first looks at capacity, then options, and then cost of benefits. And I'll just give you a couple of quick thoughts on each of these 3 things, because it's very much, this is the stuff you need to go through. In terms of capacity, it cross-references to the MPS UD and housing business capacity assessments therein, which we'll all be fairly familiar with. For your specific site that you want to get rezoned, expect debate about what the catchment is, what is the single housing employment market we're looking at in terms of the capacity. Expect debates about the HBA methodology, whether it's valid or not. Important to note clause 3.65 as well. So the MPS UD in terms of capacity just seeks the minimum. It doesn't mind if you have more capacity, as long as it's a well-functioning urban environment. Clause 3.65 flips that presumption on its head, and it's very much you can only rezone the minimum you need to get to the minimum amount of capacity you need. So it's very much kind of a just enough and no more approach. So just be mindful of that when you're looking at capacity. It's the MPS HUD presumption is flipped. Then in terms of options, your search area for where are alternative sites, Clause B talks about being in the same locality and market, which is subtly different wording to that used in the MPSUD. So expect questions on what is the locality, what's your search area. Then in terms of your options assessment, it's not a Section 32 options assessment. So we're very familiar with the sort of your Section 32 tests are proportionate to the scale of the plan change, but that's not the test. It's the test as set out in Clause 2 of 3.6. And so that requires you to first look at where your search area is, what's the geographic scale that comes to that locality conversation. And then there will be questions about what's the level of detail required. And certainly the MFE guidance is that a robust assessment is expected, which makes it quite onerous for private plan changes rather than a whole district plan review process. Once you've got your geographic scale worked out, you've worked out your level of detail you want to go to, then you have to work your way through a sieve. So are there other infill options? And that's going to be challenging if your area is adjacent to a tier 1 location that's introduced MDRS, where under MDRS there's theoretical capacity to the moon. So the debate will be around feasible capacity. If you pass that, or if you prove that there aren't infill options, then you have to look at, are there any other non-HPL options, locations where you could go? And failing that, are there any lower level LUC options, so areas that are LUC 3 rather than LUC 1? If you get through all that, then you can still only rezone the minimum required to get to the capacity shortfall. So pretty onerous tests. In my view, it may well be easier for industrial warehouse zones to get through these tests rather than residential, simply because there's less infill options available usually, and generally fewer locational sites that might be suitable as well. Finally, you get through those first two tests, and then your last one is a cost and benefit assessment, which is perhaps this is where the sort of 3.10 style assessment around constraints could come into play. Now, my sense is if you can pass A and B, you'll probably get through C. But A and B are the big chunky challenges. Thanks. So what about resource consents? With resource consents, completely different clauses. I think you look at 3.9 first in terms of whether you can meet any of those exemptions, and fingers crossed you can, because that's going to be your easiest pathway through. If you can't, then you're on to 3.10, which looks at constraints. And these constraints talk about economic viability. And this is an area that I've seen really wide diversity of practice, where taking a 4 hectare block is economic viability tested on a return on capital. So you pay $500,000 for your lifestyle block. Do you have to be able to grow enough stuff to get an economic return on that $500,000 investment for it to be economically viable? Or is it a standalone farming unit? So can does it generate enough income to support a family? Or is it simply you can buy 5 sheep or 5 lambs at the start of summer for $50 each and sell them at the end of summer for $100 each? You've made a profit, therefore it's economically viable. So this is one of these areas where I'm seeing really wide divergence of practice around the country. As a final note on subdivision, again, something we're still wrestling with a bit is where generally subdivision has a RD discretionary status as its base. If the assessment matters for that RD activity only let you look at, say, natural hazards and service and connections, can you jump up to look at an MPS that says prevent subdivision unless this very narrow band of other things is available or not? And then again, I'm seeing councils wrestle with this and come up with quite different interpretations on that. Thanks, Michelle. So look, finally, as with every flashing light, proceed with caution. Before leaping straight into getting a soil test done, I think you're far better to just stand back, take a deep breath, work through carefully, are you indeed a HPL, especially in this transitional phase, and then make sure you're using the correct clauses and asking the right questions. Finally, if you or your clients have got any interest at all in future urban growth, directions or network infrastructure that you've got planned, then I think it's absolutely critical that you engage with the regional council mapping exercises over the next couple of years, especially if your land is constrained or does have some sort of fragmentation to it, and you have got a reasonable chance of getting through those regional council processes. Because if you can get excluded, that's going to make life a whole lot simpler. Thank you.
Thank you all. We have covered a lot and I'm very conscious of the time, but we have had a few questions come through. So if anyone wants to stay on the line for a couple of minutes, we'll work through those. A number have been answered by our speakers throughout their presentation. There's been a number of questions around the site-specific assessments, which I think have been covered off. But I think this is probably one for Reece and maybe Jono. It's around the large and geographically cohesive area. And a question around if there's any guidance on that, what it may or may not cover, and what sort of scale should regional councils be working to. I'm not sure, Reece, would you like to offer any comments first?
I can have a go. I think it's a bit of a grey area as well in terms of what is large and contiguous. I did ask that question to someone at regional council last week, and it wasn't clear. I suspect it would come down to scale of mapping, and it depends on how much detail they go into. But if you would apply the 1 to 50,000 scale, the boundaries are clear. And again, how you dissolve out any small areas of non-hybrid, i.e. LUC class 4 to 6 land within 1, 2, and 3, that is yet to be kind of figured out. That would probably be my overshot of it at the present time, which isn't very helpful, but I think it's basically because there's no guidance that's very clear on it at the present time.
Yeah, look, I would agree with Reece. I think, again, one of these grey areas, I think it will come down to a sort of pragmatic scale and degree assessment. I would expect small blobs of 4+ surrounded by 1 to 3 to just be rolled into that 1 to 3 assessment, and conversely, small blobs of 1 to 3 that are surrounded by something else will be excluded. It's like your fried egg, and it's sort of the question will be around the edges of that fried egg and what's in and what's out, and how sort of curvy do the regional councils draw the line.
Thank you both. Another question around, is anyone aware of applications that have got through clause 3.10?
We have done a few that have. In general, it's been where they've been rural facing. So there's still been a bit of an argument around, it's sort of typically like a rural contractor's yard or something that sort of has a bit of a nexus with the rural environment. And where the use has only taken up a very small portion of a much larger site. So, the kind of the sheds on 1,000 square meters of a 4-hectare property, but not easy. And in fairness, I think that's because councils or everyone is wrestling with these sort of new provisions and trying to work out, what's an appropriate level of detail to justify these things. So, I have seen projects getting through, but they are not easy to get through. And it's clearly as intended by the legislation.
Thank you. And perhaps just a final quick one for Reece, which is a point of clarification where you referred to the slope of land classification. Just a question around what that means for high country farms, HPL or not.
Well, in general, most high country farms or hill country is going to be class 4 and greater. You will get some areas that are, so the cutoff there is in general sense, it's between 3 and 4 is a slope for a land unit of greater than 15 degrees will take it into 4. So it's quite steep. You'll get, if those know about hill country farming, you'll get those little terracettes on the slopes. When you start seeing those, it's probably out of highly productive land. Most hill country should be pretty much mostly not highly productive land.
Thank you. I'm afraid I think we will have to conclude there. So I would just like to thank each of our 3 speakers today, Rebecca, Reece and Jonathan, for their time and their really useful insights into these issues around implementing the NPS for highly productive land. Thank you to everyone who's attended today's webinar and is still on the line. And thank you to Michelle, who has once again organised and run a smooth webinar operation. It has been recorded and the recording will be made available. So ka kite anō, and I hope to see many of you at the conference in Queenstown next week.